Hello, in this relatively short lecture we're going to look at the employment contract. Now this is the agreement between the parties, the employer and the employee. And to all intents and purposes, it's just like an ordinary contract. We need offer and acceptance, consideration, i.e. your salary, and you turning up at work to do your job, and of course an intention to create a contract. Now, although in many cases an employment contract is a written document, it doesn't have to be. There is a strange requirement that says, although you don't need a written contract, you do need written particulars of employment. And we'll come on to those in a moment. So, we have this contract. Therefore, just like any other contract, if you wanted to change the terms of the contract, you'd need to have the agreements to both parties because you're varying the terms of a legal document. There are a couple of exceptions to that though. A contract might be changed because there is new legislation which imposes a term into an employment contract, for instance, a new minimum wage. Also, you can build in a term into your contract which in effect gives the employer the right to vary it, or maybe in some cases the employee a right to vary the contract. And a key example of that is a mobility clause, a term that says you can work anywhere, for instance, in the UK. For instance, I have a friend who has worked for the civil service in Bournemouth as a trustee in bankruptcy for 25 years. And suddenly, there's talk of asking staff to move around because there is a term in her employment contract that says, as a civil servant, she will work anywhere in the UK that the government requires her to do so. Now, fortunately, there is some case law that says that if employers are exercising their rights under a mobility clause, they have to exercise that power reasonably. And this 1988 and 89 case illustrates that quite well. In this case, an employee had a mobility clause in his contract, and it was pretty wide. It said he could go anywhere in Great Britain. And his employer gave him very short notice to transfer from Leeds to Birmingham. Now, you might think that's not too far, but this particular employer couldn't do that. His wife was quite ill. He needed to sort out his affairs, transfer his wife, find a new place to live. And he didn't refuse to be transferred, but he asked if he could have a few days' leave to sort things out, and maybe if the move could be delayed for a little while. The employers didn't even bother to reply, and therefore the employee left and claimed something called constructive dismissal. Now, we'll look at constructive dismissal in a little while, but basically it means that the employee can treat the contract as if it had been breached by the employer. Now, the court looked at this case and they said, yes. They said there's an implied term into the contract of employment that any mobility clause or any flexible provision like that would be exercised reasonably. And one of those key requirements would be reasonable notice of the move, not 3 days. Now, I mentioned this requirement for written particulars. If you start employment and you haven't been given a written contract, your employer has 2 months to give you written terms of employment. These aren't a contract, although they can be treated as evidence of your contract, but on their own, they don't amount to an employment contract. What goes in those key terms? Well, there's a list here, and obviously the names and addresses of the parties. The date on which employment began, that date is crucial because that is the date that will trigger various legal rights. For instance, have you been given sufficient notice when you're dismissed? Are you entitled to claim unfair dismissal or redundancy? Very important. If you have worked for a previous employer and been transferred under what we call the to-pay regulations, which give you a sort of continuous combined period of employment, then again, we would have to say that in those written particulars. Details of your hours of work, details of your rate of pay, and the pay period, holiday entitlements, things you would expect to see in this document. And then there are final 4 things in this list you have to have details of as an employee, but not necessarily in your written document. It could be that written particulars just says, have a look on the employee intranet site for these details. And we're looking there at sick leave, sick pay, pensions, notice periods and disciplinary procedures. These are all things that your employer will deal with probably in a staff handbook or something like that, which is normally available online nowadays. Now, I always find this one slightly interesting, but if you haven't been given those written particulars within 2 months of starting your employment, you can go to a tribunal and ask them to make a declaration of the terms of your employment. That's a really good way to get to know your boss and, settle in nicely in a new job. I wouldn't suggest you do that. This right is usually exercised where perhaps things have gone wrong in that employer-employee relationship, and therefore the employee needs to get clarification of the particulars of his employment before he can bring an action in the courts. Okay, now we mentioned earlier that the employer and the employee have implied duties as a result of this special relationship that they have. Now, these are the duties that are implied at common law. We'll have a look in a minute at some of the duties that are implied by statute as well. So, first of all, I always think this makes the employee sound a bit like a Labrador. He has a duty of faithful service, the FIDO duty. Really, that is not to compete with his employer, not to subvert contracts, take personal commissions, things like that. Again, sticking with the FIDO theme, a duty to obey lawful and reasonable orders. Now, be careful with this one, because you do have a duty of obedience. You're supposed to do what your employer asks you to do, but only if it's legal, only if it's safe, and only if it is actually your job in the first place. So watch out for that one. The examiner frequently trips people up on that one. You have a duty of confidentiality, not to misuse confidential information. I mean, those of you on the ball might have seen a case of Aviva where various employees sold on confidential information about people who had had motor accidents, so that different law firms could contact them and offer their services to make claims for whiplash and things like that. That would be a breach of their duty. A general duty to exercise reasonable care and skill. This is the reasonable care and skill that you said you had in the interview. So if you've held yourself out as being a qualified accountant and you're not, you will be in breach of that duty when you can't show the required level of skill. A duty of personal service. Now this kind of fits in with that definition of an employee, doesn't it, of someone who cannot delegate. So you do have to do your job yourself, unless your employer says it's all right. Finally, trust and confidence. This obligation goes both ways. It's basically about having a good relationship with your employer and your employer with the employee. Things like treating well, not starting rumours about your employer, things like that. Now, if we flip over the page, we can see the flip side of this. These are the employer's implied duties, the duties he owes to his staff. And you can see the first one there is to pay remuneration. Be really careful with this. The duty is to pay the employee, not to pay them a reasonable rate. If we dig into the small print of this duty, it's the duty to pay the amount agreed, which may or may not be reasonable, or if there's nothing agreed, then it is a duty to pay a reasonable sum. Again, the examiner can get a bit cunning the way he words his question on this one, so do be careful. A duty to indemnify employees. We're talking about out-of-pocket expenses here, popping out for a bottle of milk for the office, travel to meetings, parking fees, things like that. A duty for health and safety. Now, there's 3 bits to this. A duty to provide safe plant and appliances, a safe system of work, and competent fellow employees. Now, competent fellow employees will be more important in certain industries than others. For instance, I was recently watching some scaffolders putting up scaffolding outside our offices at First Intuition. Now, if you were doing that, you really would want your current co-workers to know exactly what they're doing, because you do have to trust each other. Probably less important in an office environment. Now, beware of this. This is a common law duty, so it comes from case law. There is also a statutory health and safety duty that we'll look at in a minute. A duty to provide work, but again, only where there is work. If there is no work, then the duty would be to pay the wages. An employer doesn't have a duty to provide a reference for his employees, and again, a lot of employers now refuse to give a reference, or if they do give one, they make it very bland. I confirm that Fred worked here from this date to that date. and nothing more. If you do provide a reference, the common law duty is to make sure it's accurate. So you can't put anything in that reference which is not checked, which isn't fair, and it can't be justified. Similar to the employee's duty, there's a duty not to disclose confidential information. And then finally, a duty to maintain mutual trust and confidence. Again, this is the same duty that the employee had. And there was quite a famous case on this one, where an employer was heard to say that his secretary was always a bitch on a Monday morning. She took him to court, and she succeeded in proving that that was a breach of their mutual trust and confidence. So be careful what you say about your secretaries on a Monday morning. Now, here's a question for you to try. Have a go at it, pause the recording for a second, and then restart it and check your answer. Okay, that's my answer. So, what have we got? Are the following statements true or false? There is a duty of mutual trust and confidence between the employer and the employee. An employer does have a duty to pay remuneration, but not necessarily reasonable. So be careful with that one. An employer does not owe a duty to provide a reference for his employee. He can refuse to do so. And finally, an employee must always obey his employer's instructions. That's wrong, isn't it? And it's only wrong because of these words here. Now, it's a good tactic with questions like that to look out for situations where the examiner is just being too precise with his wording. Must always, there's always going to be an exception to that, so that's definitely going to be a wrong answer. Now, I mentioned other implied terms that are implied under the statute. Well, a lot of these have come from European law. For instance, equal work, equal pay. Now, this isn't equal pay per hour. This is equal pay for work of equal value. And in order to bring a claim for this, you have to prove that the job you're doing is as good as the job the men are doing. For instance, a case brought by school cleaners to prove that their hourly rate should be the same as the hourly rate for bin men because their work was of equal value. Most people are fairly familiar with the anti-discrimination laws. It's now illegal to discriminate for virtually any reason: age, sex, sexual orientation, religion, disability or race. And there is also health and safety legislation. The main health and safety legislation is the Health and Safety at Work Act. And this is pretty far-reaching. It applies to employers. And it says, pretty much mirroring actually some of the common law duties, a duty to provide and maintain safe systems of plant and work. To make arrangements for safe use and handling and storage of equipment. That's where you get this situation like in The Office, I don't know if anybody's watched that, where you see them trying to teach staff members how to lift empty cardboard boxes without bending their backs. It's quite a nice sketch if you've seen it. To provide adequate information, training and supervision, and to maintain safe places of work and safe access in and out. Now, the Health and Safety at Work Inspectorate will visit various premises. In practice, they visit the ones that they think, where there's most likely to be a problem. Building sites being a big one, warehouses being another one where there's often accidents. And what they'll do is they will take action against the employer, either banning them from carrying on any more work until they fixed a health and safety issue, or giving them a warning and giving them time to fix the problem. If you don't comply with health and safety order, or if somebody is you haven't followed the health and safety rules, then you can be imposed with an unlimited fine or up to 2 years imprisonment. Now, obviously, if that's a company, you need a person to make responsible, and it's any director or senior person in the company who was responsible for this offence. So basically, the person that should have been making sure the systems were safe. Now, another point to note here is notice provisions. As an employee, you are entitled to a minimum notice period when you are dismissed or when you're let go. And this term of the notice period depends on how long you've worked there. If you have a contract that sets a notice period, then that will apply so long as that is longer than the statutory minimum. Now, statute says that the minimum period of notice is 1 week, and that accrues once you have worked in your job for more than 1 month. And after that, you accrue an extra week's notice for every full year that you work there. So once you've been there 2 years, you'll be entitled to 2 weeks' notice. 3 years, 3 weeks, 4 years, 4 weeks, right up to 12 years. Once you get to 12 years, the notice period is capped at 12 weeks. So, just have a look at this pretty simple interactive question here. Have Asif and Beatrice and Cliff been given sufficient notice? So, Asif has been employed for 12 months and has been given 1 week's notice of dismissal. That's going to be correct, isn't it? Because once he's been there 1 month, he gets entitlement to 1 week's notice of dismissal, but then he won't get 2 weeks until he's been employed for 2 years. Beatrice has been employed for 4 months. She was dismissed without notice when her employer discovered she was pregnant. Well, she has been there for more than a month, so she should have had at least 1 week's notice period. Now, the fact that she was dismissed because she was pregnant may well give her a claim for unfair dismissal, which is something we're going to look at in the next lecture. What about Cliff? Cliff has been given 1 month's notice from his job, and he's held this job for 15 years. Well, that's not going to be enough, is it? Cliff has been worked for 15 years. That's more than the maximum 12 years. He should get 12 weeks or 3 months' notice. Okay, I'm going to stop this recording here, and then we will look at unfair dismissal as a separate topic.